We have our final, but certainly not least, speaker of the day on new boat warranties. And this guy is a founder and chairman of Moore & Co. We know his name. And he's a law firm specializing in marine aviation and art law. Marine aviation and art law. He's the chairman of the International Seakeepers Society. He's currently a director of the International Superyacht Society, upon which I serve also at the board of directors. And he's got all kinds of accolades. Trustee of the U.S. Coast Guard Foundation, he's a Daily Business Review Hall of Famer. Lately, Mr. Moore has been spending a lot of time in Cuba and dealing with Cuban business. He was the first guy to obtain all the legal permits and requirements for the first commercial vessel charter of Cuba in over 5 decades. And in a super yacht conference in Seattle a few years ago, he stood up and said that I was the Paul McCartney of yacht management. I had no idea. I had zero idea what he was talking about, so it gave rise to the fact that I had to read Malcolm Gladwell's Outliers on the plane back home to understand it. It simply means that you've been around a long time. And so now the John Lennon of maritime law, none other than, ladies and gentlemen, I'd like you to welcome Michael Moore.
That's a good Florida boy, so I'd like to thank Kevin Baum, our wonderful sound man back there in the corner, for giving a little shout out to Tom Petty, our Florida native, who passed away this week. I'd also like to say thank you to Cindy Saylor, who's doing such a wonderful job of leading the International Yacht Brokers Association. And to Paul Flannery, the president. They're doing such a fantastic job, and one of the things they've done is going to directly relate to what I'm talking about today, which is how laws changed will affect your lives. Sometimes we forget that the two things you don't want to know about is how they make sausage and how they make laws. Not a pretty process in either context. But when Paul Flannery asked me to speak on new boat warranties, I was delighted to have that opportunity, because I think it's one of the underutilized weapons in the world of protecting your client's interest if your client is holding a new boat warranty. The Magnuson-Moss Act is something that really works to create a level playing field in the acquisition of products. We'll talk about it specifically, but I think that there won't be a PowerPoint. You'll have to use this right here to kind of follow along. But on the other hand, if you don't want to use your noodle, it's all written in that packet in front of you. It's really just word for word what I'm going to talk about, but try to amplify here today. Before I get rolling, I want to give a little shout out to the ISS Gala on Wednesday, November 1st. Thank you to the International Yacht Brokers Association for sponsoring, being one of the wonderful sponsors of the gala. It's always been the signature event of the Fort Lauderdale Boat Show, but always with the help of great organizations like the International Yacht Brokers Association. It's the first night of the show, Wednesday the 1st, and Mr. Bob Saxon is actually president. He was president a few decades ago. He was the founder, if you can believe it. Who's counting? But the truth is, he helped found the International Superyacht Society. He was president, and now in 2017, he's president once again. And we're grateful for that service. But George Cooper, who was a lobbyist, if you were able to follow what he was saying, that would be an amazing thing, because it is an incredibly difficult process to try to grab votes to create law. And The Magnuson-Moss Act that I'm going to talk about is a classic example of how laws are passed and then evolve into something perhaps very, very different than what the congressmen and senators had in mind when they passed it. Now, one thing you're going to hear, I'm going to just, before I launch into this presentation, is you will hear some duplication and you will hear some repetition. Because what lawyers learn if they try cases, in our firm, we both try cases and we also do closings. We do transactions as well as litigate. And there's quite a nexus that you can readily appreciate how that works. If you screw up the closing, screw up the transaction, you will end up in litigation. So there will be duplication, there will be repetition. But what we're trying to do here is create clarity and also give you something to take away so that the next time you confront a new boat warranty, you will see it as something very, very special, a very sacred little contract that you will have if you're an end user with a manufacturer. Now, so the Magnuson-Moss Warranty Act, just like all of the things that George Cooper was talking about, and the kind of legislative change that the International Yacht Brokers Association is trying to create for the benefit of the members, back in the day, people got together and they passed this thing called the Magnuson-Moss Act, and fundamentally it seeks to protect consumers. It had a consumer orientation to protect consumers against what was perceived at that time as sort of deceptive practices of manufacturers. It is literally an act of Congress. So when in your world, one or two of you came up to me today, and it's kind of interesting because you talked about exactly the same a situation where, can this client who wants to buy this boat use this boat for coastwise trade? In other words, moving from Fort Lauderdale to Miami or Miami to Jacksonville or something, or even around a harbor. And to do that, you have to have what are called coastwise privileges. In the case of the example of the person that cornered me out next to the coffee, one way they had forfeited their coastwise privileges. Yacht was built in the United States, but registered abroad. They forfeited it, but you can restore it by an act of Congress. It's just that simple. You can tack it onto the corn bill. George Cooper will get the vote of the corn guy, the senator from Nebraska. Somebody else will get the vote of the senator from Florida, and the congressman from Broward County, and the congressman from some place, that needs a vote where they are trading votes, and that's how they pass it. They stick it right onto the end of the bill, and voila, the vessel has its coastwise privileges restored. The Magnuson-Moss Act came along. It was trying to accomplish a lot of things. Some would say too many things. But it literally tried to define what should be in written warranties. A lot of these subjects are part of what is called the Federal Trade Commission Act. But it was in addition to the Federal Trade Commission Act. It wasn't just about trade, but it was specifically about this one single thing, which was to say defining minimum contents of a written warranty. Now, one of the really powerful aspects of the Magnuson-Moss Act, and you will hear this, I think, 4 times, is if you win that case brought under the Magnuson-Moss Act, you get attorney's fees. Now, that's it just simply strengthens the consumer's hand with respect to written warranties, because a lot of consumers, unlike anyone in this room, they don't have the money to throw around. So they have to be very careful when they go hiring lawyers. There's a bunch of lawyers in the room, like David Moss, I see, and Warren Hayes right there, and Aaron Acker, Andy Martin. There's a bunch of lawyers in the room. But when you hire a lawyer right away, you got to spend some money. The Magnuson-Moss Act says you can collect attorney's fees. It's a big hammer. Now, if you want to read the act just because you like doing that sort of thing, you can find it at 15 U.S.C. Chapter 50, Section 2301, and the sections that follow. You can also feel free to call me. I'm happy to answer questions on the fly. I enjoy it, as a matter of fact. My email is right at the top of the article. It's in your packet. So if you want to talk about a written warranty, an issue with a client who's having trouble with their boat, don't hesitate to call. I'm happy to do it. This law was introduced in 1973. It is 44 years old. Like all laws, I think most of you know this, but I think it's interesting to reflect on these sort of things because some guy, a senator from Washington State, a Democrat, Warren Magnuson, decided that consumers needed more protection, and it made its way through the House and Senate and came into law on January 4th, 1975. Now, just to reflect for just a second, earlier you heard something called the Jones Act. Now, I try not to ever think about the Jones Act because I think it's very confusing, but it was passed in 1920. So whenever you pass a law, it's one thing to pass a law, it's even harder, it seems, to undo it. The Jones Act is a relic of another era, literally almost 100 years ago. Still good law. Protects American shipbuilders. Billy Smith in the back room likes it. Raise your hand, Billy. You guys know Billy. He's built a lot of boats under it that qualify for Jones Act protection. But it is almost 100 years, and 3 years to be 100 years old, right? It may be the most important piece of legislation ever passed concerning ways to protect consumers with respect to consumer items. There are two things that you have to focus on if you're trying to figure out if you qualify for Magnuson-Moss Warranty Act protection. Is it a consumer product? Is it a consumer? Is the person holding it a consumer? That's complaining, are they consumers? Is the product itself a consumer product? And that is not as simple as it may sound. The answer to those two questions is a bit of a process. We'll get to it. But basically, you have a product that's being sold into the stream of commerce of the United States of America. That's the key. It's a federal law of the United States of America, so the product is being sold into the stream of commerce of the U.S. That's a lot like what the gentleman earlier, I think his name was Goldfarb, was talking about with respect to the free trade zone, the foreign trade zone or free trade zone. You're not entering the stream of commerce, so you may have some issues of, do you have Magnuson-Moss Warranty Act protection if you're not really entering the stream of United States commerce? Some of the unintended consequences of the way things are done. It only applies to written warranties. You can have oral warranties, okay, but the Magnuson-Moss Warranty Act only applies to written warranties. You got to have it in your hand. Now, if some of you looking at these concepts that are so protective of consumers, you might be asking yourself, did these wonderful congressmen, congressmen and women, and senators have in mind yachts when they passed this law? I would submit to you that they did not, as we'll talk about in a moment, but it applies to yachts. That much is very clear because the courts have applied it to yachts, and they had to go through a two-part analysis. Is a rich person a consumer? Yes. And is a yacht a consumer product? And the answer has been yes on both questions. The Magnuson-Moss Act, as you have to kind of work through a few things to try to find out if it applies. And believe me, if it applies and you're the one complaining, if your client is complaining about their boat, I will reemphasize, it is a hammer, because it's almost draconian in the kind of liabilities that it imposes on the manufacturer. Clearly protective law to the benefit of consumers. A yacht is sold in Florida, delivered to the consumer in Florida, and then exported to the British Virgin Islands. Doesn't matter. Magnuson-Moss Act applies. If a consumer in the United States of America purchases a foreign-built yacht, and that vessel is imported into the United States of America by a distributor, Magnuson-Moss Warranty Act will still apply. That's a case involving a company we all know named Pershing. And the previous case had to do with a company called Ferretti, very well-known brands in the yachty world. So, but when you look into the historical record of the Magnuson-Moss Act, you will see references to hair dryers, and you'll see thresholds of $10 and $15, clearly indicating that the people that were envisioning the application of this law was designed to give the person who bought a hair dryer and then it stopped working, how could they possibly sue some big company for a $25 hair dryer? The Magnuson-Moss Act says we can fix that. We're going to give them a weapon that if that hair dryer breaks, they won't have to worry about the $25 hair dryer. They will get their attorney's fees. So now you're starting to get a sense of what we're dealing with here, as the way people, when they make laws, sometimes the unintended consequences rule applies. And the Magnuson-Moss Act now has enough people behind it that it will probably not be overturned anytime soon. The Federal Trade Commission did not contemplate the enforcement of the Magnuson-Moss Warranty Act to written warranties. And that's how they sort of gave up a big part of their turf when the writers of this law decided to change things. There is a historical footnote that I think is interesting, because there were actually two sponsors by the name of Moss, M-O-S-S, that sponsored, but they didn't want to call it the Magnuson-Moss Act, so it's called the Magnuson-Moss Act. But there were actually two sponsors on the congressman's side that sponsored it. There have been rulings that also define the Magnuson-Moss Act in ways that I think here again, when there's nothing more frustrating that for you, who are generally in the middle, you recommend something and your client, or whether it's on the buying side, buys it, and then the damn thing doesn't work properly. Nothing can be more appropriate than that. So there have been cases like the Toyota Motor Company case out of the Central District of California, 2011, that says, well, these vehicles were not manufactured in the United States. And in this case, they weren't sold in the United States. And since they were not built here or sold here, the particular vehicles that you're suing on does not trigger application of the Magnuson-Moss Warranty Act. So it's not just automatic. You've got to look at it and say, does this apply? If you've got a disgruntled client, you really do have to kind of do a little bit of analysis, and if you're unsure, maybe do consult a lawyer and just say, do you think this would apply in our case, because we want to give this boat back. We have right now, this week, in our office, a client, not a client, but we have a client, but the manufacturer has agreed to give the consumer a new boat. And that is not every day. In fact, it's kind of surprising and a little bit remarkable, but to the credit of this manufacturer, the deal is not quite done yet, so I won't mention them by name, but it's a credit to them that they look at, and it's all under Magnuson Moss. The whole case is Magnuson Moss. I think the lawyers for the manufacturer wrote an incredible brief, by the way. It was like well done. A 45-page brief trying to convince the federal judge in Miami that there's no jurisdiction, or Magnuson Moss jurisdiction in the states, and before that ruling it comes down, they said, listen, we have a solution here. We will give you a new boat. It's a nice yacht. It's a sport fish, but a very nice yacht, sport fish yacht. So to kind of repeat and emphasize, anybody who is the consumer of a good for personal use, it would pass the consumer test. It can't be held for resale. You have to be the end user. It can't be a business saying, I'm entitled. No. In fact, the business often is taking themselves out of the deal because they're not the manufacturer and the warranty is flowing to the consumer through the business. But again, to emphasize consumer. It would be someone that comes to you and says, recommend to me a purchase, and you recommend it, and then it just goes completely awry. That's when you bring out the long knife, the big hammer. The supplier can be anyone engaged in the business of making consumer products directly or indirectly available to consumers. Suppliers are not necessarily covered by the Magnuson Moss Act. So a lot of people who are distributors around Florida, your principal turf, may not be subject to this federal warranty act. And the warrantor, however, is the person who undertakes these obligations as set forth in the warranty to the person who is handed the warranty, a written warranty, and handed that warranty at or before the time of sale. If they don't hand it to the customer, the consumer, at or before the time of sale, they have opened the gates of hell under the Magnuson Moss Warranty Act. Why? Because how can you protect a consumer if they don't have the ability to look at the warranty before they buy? So the Magnuson Moss Warranty Act says, before you buy that hair dryer, you have an absolute right under U.S. law to have that warranty handed to you prior to the purchase. After the purchase, no good. I'll bet there are people in this room have done deals and people have said, well, we'll just mail you the warranty later. Don't worry about it. We'll get that to you. Or, we'll just go ahead and close today, and next week we'll send you the warranty. Don't worry, it's a good one. You can see it on the internet. Not going to happen. Not going to work. The federal statute is very, very clear, and most of these things are enforced in federal court, and it will be enforced in federal court to the literal interpretation of the law. So to go a little bit beyond the idea of a yacht being a consumer product, which it clearly would be, but all those things that are also being purchased that are part of a yacht, a yacht has a lot of component parts. But anything that is, you have to do a fact finding. It's not intangible property, it's tangible, it's a real product, and it's intended for use by a person or a household or a family, that's what triggers this definition of consumer products. It's not the way the person uses it. I can't even think of an example of how a person would use a product that's not, would take it out of the consumer category. But it's not the way it's used. It's the intention of it when it was sold at the time it was sold. When you're looking at these warranties, generally speaking, you're going to see at the top, every now and then you'll see these kind of wackadoodle drafting errors, but who knows where they came from. Every now and then you'll get just a bad translation is what I would attribute it to. But if the person representing the manufacturer doesn't understand the Magnuson-Moss Warranty Act, then they may have just bought the farm right out of the box. But generally speaking, you have, sound like I enjoy litigation. I don't mean to sound so gleeful, but generally speaking, it's just, it is a sad day when someone gets it. You hear a lot, is there a lemon law in boats? We know there's no lemon law, but we all know what is meant. Well, what's your trouble? You have to drill down and see what the problem is. But first, let's take implied warranties off the table, because that's, I think David Moss touched on that. And just to kind of reinforce what that is, there's two basically implied warranties. One is a warranty of merchantability, and the other is a warranty of fitness for a particular purpose. And these are kind of implied in all products, almost all products sold in the United States of America. Fitness for a particular purpose means a can opener will open a can. You can't sell a can opener that doesn't open a can. So it will do what you say it will do, or you will have a lawsuit to force the manufacturer to give you a product that does what they said it would do. Merchantability is a little bit of a different concept that has to do with conforming to a buyer's expectations. You don't expect a product to blow up in your face, so you kind of have to use a common sense approach on those two things. But they're totally related. Implied warranties are totally related to written warranties, because implied warranties, as the name infers or suggests, is they're implied. They are not written down. Sometimes you'll see language that kind of codifies them or states it, but generally they are implied in all contracts. But if you look at a 95 to 90, maybe 99% of warranties these days will have the words either full or limited at the top. And if it's a full warranty, then it has to be very conspicuously brought to your attention that it is a full warranty. If it's not conspicuous, then here again, it will not be enforceable. Gates of hell open. It doesn't have it doesn't have a duration. A full warranty does not have a duration within the terms of the warranty. You can limit a warranty, but that's a limited warranty. But a full warranty is, as the name implies, it's a full warranty. It applies not just to the person who buys it, but to any other end users. A classic hallmark when someone comes in the office and says, well, I didn't buy this boat. I had this broker, and the broker sold me this boat and has a 5-year warranty, but there's 2 years remaining on the engines. Okay, let's take a look at it. Let's see what you got. What's the problem? But it doesn't apply just to first or so-called original purchasers. They can't charge you under the Magnuson-Moss Warranty Act for service under that warranty. They can't charge you. If you see a little charge in there, well, we charge for this or that. No. Not allowed. Generally, you will see the words repair or replace, because that fundamentally is what a warranty is all about. It becomes a bit of an issue when you're dealing with a $25 million motor yacht. And you go, well, you got a choice. You either repair it or replace it. And the only requirement of the consumer is proper notification. You have to give them notification and say, here's my trouble. And that's something that people can help you with, is what is your trouble? You got to give proper notification. One of the things that I think is important to note is that services related to the warranty are so-called service contracts, which we see quite a bit of. Those are not under the Magnuson-Moss Act. Again, it's a tangible property. It's not a service. It's a tangible property. It's just something you can hold in your hands and look at. The Federal Trade Commission came along and actually, one could argue, decided they were going to get into the act of, I guess you would say, sort of clarifying the Magnuson-Moss Act. They couldn't really change it, but they do have certain jurisdiction. The Magnuson-Moss Act, in theory, is sort of a subset of the Federal Trade Commission, which has total, jurisdiction over trade in America. And so they have enacted some regulations basically governing disclosure on consumer products and warranty terms and conditions. And they set a threshold for triggering the Federal Trade Commission. The threshold is that the product has to be worth more than $5. $5, yes. Is this thing on? $5. It's not a very high bar. They also say some things that are pretty obvious, and that is that any ambiguity in the disclosure is construed against the drafter. That's fundamental contract law, but the FTC just want to make sure everybody got it. So they actually have it in their regulations that the ambiguities are construed against the drafter. Well, there's only one drafter. I mean, the drafter is the manufacturer, right? I mean, you get it and it's like handed to you. But if you can find an ambiguity in there, it's going to be into your favor. The one thing that I think the FTC did properly to supplement the Magnuson-Moss Warranty Act, because it was getting a little out of control, was they barred tie-in sales. You cannot say that if you buy my product, then you can only buy Ferretti this or Ferretti that or Pershing this or Ferretti, just use any brand name you want. It's not permitted. There may be if you can show that there's no other way to service the product except by ordering something that's so totally unique that you have to use it in your product, it's legal. But you got to, if there's an alternative, it's not legal. You can suggest, and we'll get to this, but you cannot require. Now, on the implied warranties, I think we talked about the fact that it's a little bit counterintuitive, but on the implied warranties, they don't have a duration. But on the other hand, if you specifically limit your limited warranty, this is, to me, it's completely inconsistent with the thinking. But as I read it, you can then limit your implied warranty. If you limit your limited warranty is limited to, say, a 2-year period, you can actually then limit your implied warranties for the same 2-year period. You would think it'd be just the opposite. You would think, well, on full warranty, if you give a full warranty, that's better than a limited warranty. So a full warranty would give an open-ended time bar to implied warranties. And that is true, but if you give a limited warranty, you can limit the implied warranties, which I find to be a little bit counterintuitive to what I think was really intended by the drafters of the of the law. The FTC wants to make sure you understand that the FTC was not superseded and that it does not restrict any rights that are given under the FTC. One of the reasons that you have that is you have something called the federal preemption doctrine. And what that means simply is that to take away the rights of the states, you have to have something at the federal level that totally, squarely addresses the same issue. And under that doctrine, the state law is preempted. This is something that, it's a federal state balancing thing that works. But if it doesn't fully and squarely address the state law will continue to have force. I'm trying to think of an analogy, but you just maybe take it on faith that if the federal preemption doctrine only applies if you've got a federal law that squarely addresses Magnuson-Moss Act is a federal law, it will preempt state law. So if you're reading, sometimes you'll see this, a lawyer comes into court and he's arguing away on state law, and he's got some wonderfully informed or well-intended state legislature has done something, and then you go, well, hang on a second, Your Honor, the federal Magnuson-Moss Act actually addresses that, which means Magnuson-Moss controls, and the court will always say, you're correct, and I do find that it's preempted. But the Magnuson-Moss Act, the intent there is that it really is supposed to be the singular guiding authority on consumer product warranties. Let me say this. I think we're getting to the drinking. I think the drinking lamp has been lit. Let me see if I have any pearls of wisdom here that I can drop on you in the next moment or two. Did I mention that you get attorney's fees if you win your lawsuit? Did I mention that? Okay. I think we got that one, right? I tell people I'm slow, but I'm dependable. But when you're talking to a jury, remember, you got to get every single one of them to follow you. So you got to look at them. And, the smart ones are doing like this all the time. And the ones are, you go, hang on a second. You get attorney's fees. And I'm just saying, it's not because they're not bright, but sometimes they're daydreaming. So anyway, I'm only through page 17 of my outline, and it's a 26-page outline. But as I said before, it's in your packet. You can read it. It won't be as entertaining as me, of course, but I'm just kidding. All right, thank you very much, everyone. Let's do some drinking. Thank you, sir. And God bless Tom Petty.
Any questions? Right here. Hang on. You think you understand?
Okay. Here it goes.
I have a question about your new boat warranties.
Yes.
Going back to your, stating to the customer.
Yes.
We give copies. We have our customers sign the warranties when they sit down and sign contracts.
Smart.
Are you also saying that we should make sure we give them copies once we register all those warranties? Because we do.
No, you've already met the requirement, which is it's that consumer protection thing. They have the right to comparison shop, in theory.
Okay.
Compare and so forth to other warranties. So when you did the first part, when you gave them the warranty and you can prove that you did that, that's smart. That's a very smart way to run a business.
Wonderful. Thank you.
Yeah. And it's the proper way to do it.
What is proper notification?
Well, I think...
Would you repeat that, Mike?
What is proper notification? I think it would be fair to say that is, you can search lawyers from the insurance world, and believe me, I've gone blind in reading some policies to answer that question. There is a fact-finding, and actual notice is always good, but it's a fact-finding. Did you give proper notification? And it becomes a major issue. In the world we live in today with these automatic electronic records, I think just proving that you gave notice to the right party is the key. And that I think that the courts will accept as the best available evidence. But you really need to prove that you gave proper notification to the manufacturer. And as part of that, by the way, I don't think I mentioned this, the manufacturer does have a fair opportunity to make the product good. You can't just say, I got you. You have to give them a fair chance to make the product good. So that's a frustrating thing sometimes, but it's a necessary part of the process.
Last chance. Any other questions? Fantastic, Michael.
Okay, we're okay?
Thank you.
All right, guys.